one big common misunderstanding is thinking that healthcare, because it's so critical, because it's so essential, is in some way insulated from, being held to account with some of these compliance standards. I always tell folks, healthcare employers are subject, to the same employer compliance standards as any other industry.
Welcome to Off the Chart, a business and medicine podcast featuring lively and informative conversations with healthcare experts, opinion leaders, and practicing physicians about the challenges facing doctors and medical practices. My name is Austin Luttrell. I'm the Associate Editor of Medical Economics, and I'd like to thank you for joining us today. Before we get started, just a quick note, Physicians Practice will be hosting Practice Academy's new practice management track on Thursday, March 19th. The virtual learning experience is designed for physicians and practice administrators looking for practical real-world strategies to strengthen operations, improve performance, and build stronger, more resilient practices. Speakers include Anders Gilberg of MGMA, Bronson Cox of Encoda, Justin Lamb of Coolblue VA, and Mark Herzog of Veradigm. You can register today by clicking the link in the show notes or by going to registration.physicianspractice.com. That said, in today's episode, Keith Reynolds, the managing editor of Physicians Practice, sat down with Katie Russell, a partner at Brown Immigration Law in Cleveland, Ohio. They're talking about what recent shifts in immigration enforcement mean for medical practices, including how workplace compliance audits are evolving, what employers need to understand about I-9 documentation, and how to respond if federal officials arrive at a practice. Katie also explains changes to H-1B visa rules, including the new $100,000 fee, and what practice leaders should and shouldn't be worried about in 2026. Katie Russell, thank you again for joining us, and now let's get into the episode.
Hey there, folks. Today we are talking to Katie Russell, a partner at Brown Immigration Law. Katie, how you doing?
I'm doing great, Keith. How are you?
I can't complain too much. We chatted back, I believe it was in October, maybe September, and we talked about all of the stuff that was going on with immigration in America. Feels like it's been a million years because that much has happened since then. So, without much ado, let's dig right in because there's quite a bit. So, since October, what are the most significant changes you've seen in the way that ICE enforcement is being directed and how it's sort of affecting, let's say, medical practices, but just sort of businesses overall?
Definitely. So, quite clearly, there have been many changes and lots of media coverage of the various new ways that ICE has been utilized. Now, luckily for medical practices, not a lot of fireworks going on here. I would say that the biggest shift that we've seen really is more towards, employer-focused enforcement issues. So less about having dramatic raids, and it's more about scrutinizing compliance documentation. It's a real snoozer. There's not a lot of, like I said, not a lot of stuff that the media covers with this because it really doesn't get the clicks. But things like I-9 form completion, that the forms are done accurately, record retention, and visa petition adherence if you've got non-citizens that are working with you on work visas. So, with the I-9 form, sometimes I'll talk to employers and they're like, oh, I'm not familiar with that. I'm like, well, that might be an issue. Please ensure that you have an admin or HR that is working on those. But, the Form I-9, that is required for all employees, regardless of immigration status. And yes, U.S. citizens must also complete them. Even a small technical error on that little form or even an outdated policy using the wrong addition, not completing the paperwork properly, that can trigger exposure. Now, I-9 audits, they're very rare. But I have received many a panicked call from local businesses that say, hey, I got this weird notice. I have 3 days to turn in all my I-9s and supporting paperwork. I don't know what this is and what do I do? So, we can still try to address things in that 3-day period, but the best recommendation I have is, look, you want to be proactive. And, this might not be the most exciting thing. We do internal I-9 audits quarterly. I'm in charge of our I-9 binder. It's just something that's kind of, we've seen enough horror stories come across that, we really just encourage employers and HR departments, admins, whoever it is, just make sure you're documenting the I-9 paperwork, supporting documentation, You want to have that done and taken care of. It's easy, make it part of your standard onboarding, because let me tell you, the fines and penalties can be substantial if a practice is not being proactive and doesn't have all that lined up. So the practical takeaway I would say is, it's not so much dramatic enforcement operations that we're seeing being launched on practices. It's really administrative. So it's compliance driven, not operationally disruptive, but it is still good to make sure that you're in a good position.
Okay. So, you mentioned that it's less of the dramatic stuff when it comes to, practices, more clerical, ticky-tack, we shall say, just to, we have to describe these things somehow. So how have sort of, what has led to the shift, would you say, of priorities? Because, it's, last year especially, we were seeing a lot of, workplace like raid sort of deals. What's sort of shifted? And is it really an increased risk of these sort of clerical issues compared to, years past?
No, I mean, I would say that, this is something that's pretty consistently come across our desk, and, we'll get, contacted by, different companies. It's not something that's new, I guess I'll say that. It's just something that we've seen kind of a low volume of those just kind of in the background at all times. The best thing that you can do really is just being prepared. Making sure you have all that documentation done, that you have good training. I have been hired by a number of different employers recently just to come into their offices, come into their practices, and just sit down and meet with everybody on staff. What happens if ICE shows up? What type of documentation must be provided? Having like a contact person or a go-to person with, kind of like a walkthrough of, all right, these are the things that we need to do if an ICE officer shows up, or even if it isn't ICE, it could be another type of, federal immigration office that may want to come up to be doing a work site visit. It could be something like someone here on an H-1B visa, for instance. Those aren't necessarily ICE, but those are still immigration officers or folks that are coming in just to ensure that, there's a proper filing in place, that the right disclosures have been made, that the person is doing the job that they're supposed to be doing. So, it really does not get the media attention because these aren't like fancy fireworks, but it's more of a background thing that I always tell folks, if you have us come in or have an attorney come in or have your HR go get some training on I-9 compliance and making sure that your visa documentation is in order, that is going to save so much of a headache later on down the line if something happens. So this really isn't anything new, but because of everything else going on environmentally with immigration generally, a lot of folks are going, well, wait a second here. Like, is there any type of exposure that we could have if ICE shows up, knocks on the door? So just making sure that all your ducks are in a row. Most practices have absolutely nothing to worry about. I know that's not really going to sell much, but the fact of the matter is that it comes with preparation and planning. If you've got, a non-citizen that's working for you, or if you've sponsored a non-citizen with a work visa, you should already have had an immigration attorney that helped you with that process, either someone in-house counsel, or if you have someone that you've retained for it. We keep a very close eye on all of our employment-based cases, even after approval, because if there's a change, in someone's job duties, if there's a material change in what they do, or a change of pay beyond a certain threshold, that technically requires an additional filing to be submitted to USCIS to amend it. So it's a lot of kind of low simmering attention that needs to be spent on it, but just making sure you got the right people and practices in place, that's gonna save you so much of a headache.
All right. So, what are practices really misunderstanding about their obligations? Like, you're hearing from people that, what are I-9s? What's the big, misconnect there or disconnect?
Well, I would say one big common misunderstanding is, just kind of thinking that healthcare, because it's so critical, because it's so essential, is in some way insulated from, being held to account with some of these compliance standards. And, that's not the case. I always tell folks, healthcare employers are subject, to the same employer compliance standards as any other industry. So just making sure that you have all of your documentation done, again, with the compliance, whether it's I-9 documentation or petition terms, or just making sure that you're keeping an eye on, the expiration dates coming up on someone's visa. Is a renewal due? Should the practice be requiring someone to provide a new document? Or if they go, oops, I just noticed that your employment authorization expired 6 months ago, how do we, go about fixing that? So it really is about preparation. I think some other concerns that I've had with work sites and practices is, when do we let ICE in? Like, when do we, have to turn things over to them? That's another reason that it's really important to have, an attorney come in, even just to have like a quick hour-long meeting. We've got a PowerPoint presentation that we share with folks all the time. Hey guys, we'll get some bagels, sit through this. Hopefully this is something that never comes up, but preparation is everything. And making sure that when, hey, all right, we can handle this, or you know what, we're going to have to pick up the phone. We want to make sure that we get our counsel on this and make sure that we can step aside and make sure that we're covered there.
So, last time we talked, you sort of explained the difference between, a warrant from a judge and a administrative warrant. We're seeing in the news that there has been some mixed messaging to our brothers in ICE who, as to what they're able to do with an administrative warrant and a judicial warrant. Are we seeing any sort of increase of them trying to expand the powers of an administrative warrant when it comes to workplace enforcements?
There have definitely been instances, anecdotally, I have had some instances in which, someone comes in with a piece of paper that may or may not say what it's supposed to, or it may not be the correct warrant, for whatever access is being requested. So that's, there is a lot of, there are a lot of questions, and it is, kind of a challenging legal question as well that we are seeing quite a bit of shifting with. Is it a judicial warrant? Can we use an administrative warrant? What type of reach and what type of scope is covered under each of those things? That's something that we tend to cover under intensive trainings. Also, there is like a publicly accessible portion of most practices, and then behind a certain door, those cannot be accessed unless consent is given, or if there is a warrant granting that access. So some of the site visits that I have done is, all right, we kind of walk out there. Hey, this is the area that, it's open to the public, folks can come in, but then beyond a certain point, this is the hard line that folks can't come through. Do not grant access, unless you have something. And honestly, we're on call for a lot of those scenarios because, practitioners want to protect their staff, their patients. This is something that's affecting, real people and real individuals who find themselves in very, very vulnerable situations that if you have with someone that's going in for medical care, they need that medical care, and they shouldn't have to be worried about, what could happen, or should I skip this doctor's appointment because I'm afraid that, an agent or an officer may come through. And, I'd say just knowledge and training is the best way to go about it.
Okay. So I'm going to throw a hypothetical at you.
Yeah.
So say we're in a practice, there's some sort of DHS employee trying to get in. They have a warrant. Our staff don't know if it's a judicial warrant or an administrative warrant. They have not done the background. They're not prepared for this moment. In the split second, should they try to keep this DHS employee out of, client or patient spaces, or should they, just let the DHS employee, do their thing and worry about it in court later?
And that's a great question. Honestly, that's what happens. And, a lot of times folks will freeze because they go, I want to do the right thing. I don't want to be, impeding an investigation, despite, a lot of the negative press, there's our federal agents and officers are doing a job. and often they're doing a very legitimate, important job that we want to make sure that we're not impeding improperly. So, I always tell folks, first verify the warrant, ask for it, not, hey, it's in the mail, or here, we're going to let you know. You need to have someone who, again, is trained to look for, certain languages. And we've got, a handout we can give to folks with redacted examples of what these different types of warrants really look like. Look at who the issuing authority is. Is it, an internal ICE officer? Is it a judge? What is the scope and any limitations that are placed on it? Because that's going to be something that's specified in a warrant. Don't just ignore. Until verified, staff should not grant unrestricted access. Everything should be documented. Note the officer's name, badge number. Sometimes they have a card with them, the time of interaction. Keep a photo or copy of all of that documentation, and call counsel. I would say that that's going to be the most important thing to do. If they're really feeling pressured, or, they've got something and this looks legit, and this looks like it's specifying, it's signed by a judge, it's specifying our address, it's saying that they can search and seize certain things, then you do have to allow them to go with that. But that's why having counsel is so important, because those are split-second developments. And there is always an element of surprise. They really don't give you advance notice, so you can make sure you've got, the person with the briefcase there ready to go through it with a fine-tooth comb before they grant access.
It's the Monty Python thing. No one expects the Spanish Inquisition.
No, it's always the Spanish Inquisition, man. It's gotcha.
Hey there, Keith Reynolds here, and welcome to the P2 Management Minute. In just 60 seconds, we deliver proven, real-world tactics you can plug into your practice today, whether that means speeding up check-in, lifting staff morale, or nudging patient satisfaction north. No theory, no fluff, just the kind of guidance that fits between appointments and moves the needle before lunch. But the best ideas don't all come from our newsroom. They come from you. Got a clever workflow hack, an employee engagement win, or a lesson learned the hard way? I want to feature it. Shoot me an email at kreynolds@mjhlifesciences.com with your topic, a quick outline, or even a smartphone clip. We'll handle the rest and get your insights in front of your peers nationwide. Let's make every minute count together. Thanks for watching, and I'll see you in the next P2 Management Minute. So, in every group, there are those who straggle behind, we shall say, and don't keep up on certain things. So for groups that haven't updated their compliance plans in the past year, what's the first thing they should have right now? Like, what should they be revisiting?
All right. Well, it's the most exciting thing that they will do all year. They have to check in with their HR, their admin. No matter how big or small a practice is, you've got employees in the United States. You've got folks that are in charge of onboarding. They have to do the documentation. They've got to complete the I-9 form for every employee. That form isn't just something to just stuff in a mystery file or stick on a shelf somewhere. You got to keep them organized. All right. So no matter how big or small, or how far along, how organized a practice may be with things like I-9 paperwork, which is clearly, like I said, the most thrilling thing you can do. The most practical thing is, just do a check-in. Where are you? See where you are at this documentation first. Let's, is there a policy that we have? Is, the designated employee who is completing the I-9 paperwork with new employees, are they trained? It might be a good idea to do a training refresher, of the many, many responsibilities that admin or HR are tasked with running a busy practice. One of those things, it's going to have to be this documentation, and it's always good to have a refresher. If you look at the I-9 form itself, it's really not all that intimidating. People are like, this is fine, I got this. But, there are certain deadlines that, part one is going to need to be completed, before they start, or on the same day that they start, and they've got to inspect the documentation within 3 days of hire. There's a lot of little deadlines that are important to be mindful of. So having an internal policy doesn't have to be anything complicated. It could be a one-pager. just to go through a checklist. When onboarding someone, make sure you go through it all. Make sure it's documented correctly. You're signed up for the E-Verify system. That's basically doing the I-9 online, and you get immediate verification and confirmation back that the government says, yes, this person is who they're saying they are, and that is their correct documentation. Do that. Make sure you have it. Keep it all organized and together. So I'd say checking in. What do we got going on? Do we have nothing and we're just building this from the ground up? That's going to be better than where you were before. Keeping it together, keeping it in the binder, and reaching out for help. There's a lot of really great resources, not just attorneys, not just immigration attorneys. There's a lot of really great resources out there that you just want to make sure you get that put in place. So having a plan, checking in, how are you doing? And sometimes talking to an attorney if you don't know where to start or you want a template. That's something that we help folks with too.
All right. So, with that, I'm hearing about all this administrative, just, paperwork, making sure your paperwork's in line. Is there, and, I'm not an attorney, if you could guess. Is there a point in all this besides just trying to trip up businesses and practices? Is there an affirmative reason for this beyond just, trying to trick people?
I know, and that's really what it feels like. And I know that, that's not why these laws were set in place. If you look at it, something like the I-9, it's really just a very low bar threshold that, hey, you want to work for me, we've just got to make sure that we've got confirmation that we have your identifying information and that you have permission to work here. So I don't mean to, I never want to stress employers out. I never want to, stress doctors out when they're running their practice, but, it really isn't designed to trip people up. Again, it's just more of a paperwork thing. I know doctors are no strangers to the fun and joy of just endless paperwork and documentation. It's just one of those things that, you just got to do. Hopefully you go through an entire career never having to once worry about it or question where is our I-9 binder of documentation. But it's just good to have it as insurance in the background. And I will use the insurance thing against them because you know what, it is something good just to do that to make sure you're not going to have issues. Keep yourself covered.
The CYA School of Law. I get it.
The name of the game. That's the name of the game. That's all it is.
All right. So let's turn now to the new $100,000 fee for H-1B visas. How does this actually work? And, who's bearing the financial responsibility of these, seemingly, again, from a layman's point of view, insane amounts of money?
I think that, that really is a legal term of art when we're talking about some of the changes that were announced last year to the H-1B program. And there was considerable panic. We have a very broad and diverse kind of corporate client base here at the firm, and small businesses, large businesses, huge corporations that when they're looking for talent and they're looking for someone to fill a position, the first question in their mind isn't always, well, are you a U.S. citizen? Are we hiring American? That's all well and good, but in some of these very critical fields, you want the right person. You want to make sure that, hey, I like this person's background. We see eye to eye. We are aligned. And this is someone that if I'm hiring someone on to be helping my clients or serving my patients or working shoulder to shoulder with me in my practice, I want to be able to have the ability to bring them on. So there was quite a bit of panic about, is this the end of H-1B? Does this mean that we can't bring these workers anymore? Luckily, that is not the case. Unsurprisingly, I think it was kind of a door in the face technique with the administration and how this was presented to all of us. It just, hey, you're going to have to pay $100,000, boom. Of course, the initial announcement was not, I would say, detailed or nuanced in, kind of the sense that attorneys are looking for, all right, well, there are so many different situations in which an H-1B can be utilized and so many different, answers that we need to be able to give not only ourselves but the folks that we serve. So as time went on, there was additional clarification, and luckily we've been able to come to an understanding that for the majority of our clients, they're really not affected. Now, this $100,000 bounty, whatever you really want to call it, from the White House's perspective, they're looking at it through, the lens of their agenda. This is to reduce the incentive for hiring foreign workers, based on lower layered costs. We want to aim to protect American workers. And that's all well and good. But ultimately, with the H-1B generally, so it's a very common work visa for professionals, for specialized occupations, dentists, physicians, you name it. It is an employer-sponsored process. That means that the employer is the petitioner, meaning that they are our client when we're working through this to help them bring a worker here, but they're also responsible for these fees. Now, this $100,000 fee was clearly meant to be a deterrent, to really reduce dramatically the number of H-1B visas that are issued. However, the majority of the H-1B processes that we do are for folks that are already in the United States. Let's say they came to the United States. It's a very common pathway. They come to the United States on an F1 visa. That's a student visa. Say they're here, they go to school, they graduate, they find an employer that's willing to sponsor them, they get sponsorship. If they're doing this process from within the United States, in that they're changing their status, hopping from student status to OPT, another temporary work permission, into something like H-1B, that process has not changed. There's no $100,000 fee for that. So that has been a huge relief, because that is a huge chunk of the folks that are being brought over or being brought over into that status, is that they're already here in the United States. They have a relationship already established with an employer, with a physician here, and they want to kind of bring them on. So, it's still something that is impacting quite a few folks. It's primarily affecting the people that have not yet received an H-1B visa in the past or have never held that status. And if they are not doing a change of status here in the United States, but rather through their consulate overseas, it's called consular processing. So for folks that need to leave the United States, or in order to enter the United States, they would first need to go and get that visa, have it issued at the embassy or consulate. Those are the applicants that are subject. And I can tell you that, as we're approaching H-1B season now, the lottery's opening here in a couple of weeks. We were kind of bracing for, hey, with this new rule in effect, we're probably not going to see as many H-1B processes, this spring. And we really haven't seen any difference, which is great. So that means that, this is still a very common, very heavily utilized and properly utilized visa classification. I have no doubts that there were abuses that they were targeting and are using as a justification for cracking down on this. But, luckily, the way that we've done it with our firm, we have not seen any changes. We're hoping for no bumps ahead, but that $100,000 kind of deterrent penalty, it's not every H-1B. It's many, and it is going to make harder for folks overseas that are looking to come work in the United States, but it's not as bad as we were all bracing for.
Okay. So when one of these, these consular H-1Bs are coming over, who pays that? Are they paying it, or the company that's bringing them in? Like, who's dropping the dough?
Well, I mean, I don't know who's going to be dropping the dough, because that's, it is an amount that it is so, that's more than the wage. That's, often more than the annual salary that's offered to someone. So, all fees need to be paid by the sponsoring employer. And so, again, that's a hard pill to swallow. That I'm sure that there are folks out there that aren't batting an eye to make sure that they get the right person to come over to fit their business's needs, but it's a pretty tall order.
Yeah, it seems, it's not going to be a problem for the Cleveland Clinics of the world, the Johns Hopkins, got that right. Almost said Bob Hoskins. That's not the right guy.
You don't know anybody named Johnny Hopkins.
Yeah. So, those are, those are probably not going to have a problem with it. But, the rural hospital in Wichita is probably, not going to be able to drop that sort of dough. All right. Okay. So, are there any structural or legal strategies that practices could use to try to mitigate that cost? Besides, of course, trying to hire someone who's already in the country on I believe you said it was an F1. What can we do?
Yeah, I mean, the H-1B is not the only game in town. And a lot of what we do as attorneys is, we've got this visa system in the U.S. It's, A through Z. There's a visa for every letter in the alphabet. A lot of times if we're working with someone and we're like, hey, let's just kind of spitball, let's see what we got. Let's play with the information a little bit. Let's see what we can kind of cook up in terms of alternatives. And oftentimes we can find a different pathway. We can find a different type of visa, whether it's non-immigrant, something like the H-1B. There's a lot of different type of work visas. That's not the only one that folks can pick from. There's those non-immigrant options. Sometimes there's also immigrant options, meaning that an employer can also sponsor someone to get permanent residency. So that is the pathway that we often introduce to folks and say, hey, I know you've done your research. I know you've heard about this stuff. I know you read online, before the consultation. But let's maybe take a step back and just kind of blow this thing up. Let's reimagine what this could look like. And those conversations are often so much fun because we're able to say, all right, you came into this conversation thinking that this was all you had to work with and that you had these list of problems and questions for us to get through, and we did, but we kind of blew some walls down and maybe we identified something that's going to be a better fit, maybe less expensive, maybe faster, not going to be subject to the H-1B restrictions, whether it's the fee or the lottery selection. There's so much that comes with it that often we can find better options. And that always feels really good because ultimately we're here to help people get the folks that they want, find a solution and be creative with it. So that's really satisfying. And I'd say it really just comes down to what kind of relationship do you have with your counsel. Sit down and don't just assume that you're going to do what you've done every year for every worker that you've had. A lot of times there's better options and things that can be a better fit.
So what I'm hearing is become friendly with your attorney.
Yeah.
Take them out to dinner, find out what what the options are. Okay. I get it. So for practice leaders who are feeling overwhelmed by all this, the heightened ICE enforcement, visa costs, all this sort of stuff, what is the most practical first step they can take? We won't say today, it's 2:30 on a Thursday. Nobody's going to do anything today, but we'll say, this quarter, you got a couple weeks left. What should they be doing this quarter to just sort of, at the very least, ease their own stress about this?
Well, and this is something that I say to folks, whether they're running a business, a practice, if it's just, an individual, someone worried about their family. I mean, this is just advice that I give to everybody. What I have seen more than anything in the past year or so of this administration is that just knowledge is power. And I say that in the sense of, most of my 9 to 5, which is not my complete workday, I'll add. That's the fun part of my day. That's when I have conversations. That's when I have consultations, whether it's over the phone or here in the office. That is what I do from 9 to 5 every single day. And it's, cracking through issues with all different types of immigration cases, people all over the world, people from the US, just let's narrow down what we've got and see if we can find something that can work. I have really found that a much higher percentage of those conversations really aren't so much about the legal issues or some specific process, but it's just helping them get a handle on what do I need to be worried about? You don't have to be afraid of ICE jumping out of the walls to get you in the middle of the night. You haven't done anything wrong.
Alrighty. That's all I got for you. Anything you'd like to add? Anything you think I'm overlooking?
No, I mean, look, I would say that, it's just a lot of it, the stuff right now is just, compliance. Be informed when you do have a quick minute, do fit a call in with somebody, whether it's your own counsel, someone that you've worked with before, or maybe someone new, just to get your bases covered, and even just to have a plan in place for staff. Because, even here internally, we've had meetings just so that everybody feels that sense of assurance that, all right, someone's on it, we're not just left here alone in the dark. We've got a plan, we've got to go to. And that, my whole job now, I feel, is just kind of calming people down, easing anxiety, and just throwing cold water on this panic that just seems to have gripped everybody.
All righty. Thank you so much, Katie. It's always a pleasure.
Thank you so much, Keith.
Once again, that was Katie Russell, a partner of Brown Immigration Law in Cleveland, Ohio, speaking with Keith Reynolds, the managing editor of Physicians Practice. On behalf of the whole medical economics and physicians practice teams, I'd like to thank you for listening to the show and ask that you please subscribe so you don't miss the next episode. And don't forget, Physicians Practice will be hosting Practice Academy's new practice management track on Thursday, March 19th, featuring practical, actionable education for physicians and practice administrators. You can register today by clicking the link in the show notes or by going to registration.physicianspractice.com. As always, be sure to check back on Monday and Thursday mornings for the latest conversations with experts sharing strategies, stories, and solutions for your practice. You can find us by searching Off the Chart wherever you get your podcasts. Also, if you'd like the best stories that medical economics and physicians practice publish delivered straight to your email 6 days of the week, subscribe to our newsletters at medicaleconomics.com and physicianspractice.com. Off the Chart, a business and medicine podcast, is executive produced by Chris Mazzolini and Keith Reynolds, and produced by Alson Luttrell. Medical economics and physicians practice are both members of the MJH Life Sciences family. Thank you.